The judge challenged the royal guard to a game of truth or lie, but he had no idea the guard was a legal genius with a high IQ. Want to know what really happened? First, hit that subscribe button and comment below where you're watching from. That being said, let's get into it. The autumn sunlight glinted off the polished brass buttons of Lieutenant Trevor Millcross's scarlet tunic as he ascended the worn stone steps of Westminster Crown Court. His measured footsteps echoed across the marble entrance hall, drawing curious glances from barristers in their black robes and civilians waiting for their cases. The bearskin cap, tucked precisely under his left arm, added another foot to his already impressive military bearing. Millcross had not expected to find himself in these halls of justice when he'd witnessed what appeared to be a simple theft during his walk through St. James's Park. After completing his ceremonial duty at Buckingham Palace, he had been taking his usual route home when he observed a carefully orchestrated heist from the nearby Wellington Gallery. His military training had kicked in instantly, observing details, memorizing faces, reporting to authorities with precision that the investigating officers found invaluable. "Lieutenant Millcross?" a court usher approached, unable to hide his admiration for the uniform. "Your testimony is scheduled for 10:30 in Courtroom 4. "Thank you," Millcross replied, checking his watch, a simple timepiece that had been his grandfather's. He had precisely 18 minutes before his testimony was required. As he followed the usher down the oak-panelled corridor, Millcross felt the same sense of duty that guided his steps during the changing of the guard. Whether standing at ceremonial attention or providing evidence in court, service was service. Different uniforms, but the same principles. An elderly gentleman wearing a veteran's pin on his lapel gave a subtle nod of recognition. One serviceman to another, across generations. "The gallery is quite full today," the usher mentioned as they approached Courtroom 4's imposing double doors. "Judge Rathbone runs a tight ship, but he's fair. Just answer directly and you'll be fine." Millcross nodded his appreciation for the advice. "I understand. Precision and clarity, not so different from my daily reports." With a respectful nod to the court's security officer, Lieutenant Millcross entered the courtroom, his uniform a vibrant splash of ceremonial scarlet against the subdued wood and leather interior of British judicial tradition. Courtroom 4 stood as a testament to British judicial tradition, its high ceiling adorned with intricate mouldings that had witnessed centuries of legal proceedings. Morning light filtered through tall windows, casting long beams across polished oak benches, worn smooth by generations of barristers and defendants. The air carried the distinct scent of aged wood and leather-bound law books, the signature of serious legal business. At the front, elevated on a carved dais, sat Judge Julian Rathbone. In his early 60s, with silver hair framing a face etched with the lines of 3 decades on the bench, Rathbone commanded the room with the quiet authority of vast experience. His reputation was one of thorough knowledge, procedural exactitude, and occasional flashes of dry wit. The judge's reading glasses rested halfway down his nose as he reviewed documents, his black robes settling around his shoulders with dignified weight. Below the bench, the court clerk organised a series of files with practised efficiency, occasionally glancing up to ensure everything remained in proper order. The prosecutor, a sharp-featured woman in her 40s, whose reputation for attention to detail matched the judge's own, reviewed her notes while the defence counsel conferred quietly with his client, a well-dressed man whose nervous finger-tapping betrayed the calm demeanour he attempted to project. The gallery behind the barristers was filled nearly to capacity. A mixture of law students observing proceedings, journalists from the legal press, and curious members of the public drawn by the unusual case of art theft from the Wellington Gallery, a crime that had made headlines for both its audacity and the value of the stolen pieces. Lieutenant Millcross took his place in the witness waiting area, his posture reflecting the same disciplined attention he maintained at his ceremonial post. His scarlet uniform drew subtle glances from throughout the courtroom. the unexpected presence of a king's guard adding an additional layer of interest to the proceedings. He placed his bearskin cap beside him, with military precision, his white-gloved hands resting lightly on his knees as he waited to be called. Judge Rathbone glanced up from his papers, noticing the splash of ceremonial red among the courtroom's muted colours. His expression revealed nothing beyond professional assessment, though a slight raise of his eyebrow suggested mild interest in this unusual witness before returning his attention to the case files. "The Crown calls Lieutenant Trevor Millcross," announced the prosecutor, her voice carrying clearly through the hushed courtroom. Lieutenant Millcross rose with military precision and approached the witness box, his polished boots making measured contact with the wooden floor. Every eye followed his progress, the scarlet tunic, an immaculate bearing, creating a striking contrast against the courtroom's subdued palette. "Lieutenant Millcross, please state your full name and occupation for the record," the court clerk requested after administering the oath. "Lieutenant Trevor James Millcross, 3rd Battalion, King's Guard," he replied, his voice carrying the clear diction of a man accustomed to issuing parade ground commands. The prosecutor approached, her manner professional but approachable. "Lieutenant Millcross, could you please tell the court exactly what you witnessed on the evening of September 14th near the Wellington Gallery?" "Yes, ma'am." Millcross began his account with methodical precision. "I was proceeding along Marlborough Road at approximately 240 hours, having completed my duty shift at Buckingham Palace. I observed 3 individuals exiting through the service entrance of the Wellington Gallery. Their behaviour appeared suspicious, as they were moving with unnatural haste and repeatedly checking their surroundings." He continued detailing the event with remarkable clarity, noting exact times, descriptions of the suspects, and the specific artwork being loaded into an unmarked van. His recall of minute details drew appreciative nods from several jury members. Judge Rathbone leaned forward slightly. "Lieutenant, you mentioned you were able to identify one of the paintings. How were you certain of what you saw, given the lighting conditions at that hour?" "The street lamp positioned approximately 12 feet from the gallery entrance provided sufficient illumination, Your Honour. Additionally, I recognised Thornfield's Lady with Peacock Feather from having visited the exhibition during its opening week. The distinctive gold frame and dimensions of the piece made identification possible even at that distance." The judge nodded, impressed by the detailed explanation. "And regarding your subsequent actions, Lieutenant, police reports indicate you followed these individuals for some distance. Would this not have been better left to trained investigators, particularly as you were off duty and unequipped to intervene?" "I maintained a secure distance of approximately 50 yards, Your Honour. My only objective was to observe and report. Under Section 24A of the Police and Criminal Evidence Act, any civilian may follow a suspected felon to gather information when no immediate police presence is." "I believe you're referring to Section 24, regarding civilian arrest powers," Judge Rathbone interrupted, his tone carrying a hint of correction, "which specifies that reasonable force may be used only in cases of indictable offences when police officers cannot be summoned in time to prevent." "With respect, Your Honour," Millcross interjected before catching himself, "Section 24 covers civilian arrest, while Section 24A, added in the 2005 amendment, specifically addresses observation and information gathering without direct intervention, which was precisely my course of action." The words hung in the air, followed by a moment of complete silence. Several barristers exchanged glances, their expressions a mixture of shock and intrigue at witnessing a witness, particularly one in military uniform, interrupting and correcting a Crown Court judge mid-sentence. Judge Rathbone's pen paused over his notes, his expression momentarily frozen between surprise and displeasure. The prosecutor cleared her throat uncomfortably, while the defence counsel's eyebrows rose with interest at this unexpected development. Lieutenant Millcross, suddenly aware of his breach of courtroom protocol, straightened his already impeccable posture. "I apologise for the interruption, Your Honour. That was inappropriate of me." Judge Rathbone set down his pen with deliberate care, the subtle action commanding more attention than any raised voice could have achieved. His eyes, sharp with intelligence, honed through decades on the bench, fixed on Millcross with an assessing gaze that had made many a seasoned barrister reconsider their approach. "Lieutenant Millcross," he began, his tone measured but carrying unmistakable authority, "while your knowledge of the specific section is noted, interrupting this court is not acceptable procedure. In my courtroom, as I imagine at your post, proper protocol exists for good reason." "Yes, Your Honour," Millcross replied, standing even straighter if such a thing were physically possible. "I apologise for the breach of protocol. It was not my intention to show disrespect." Judge Rathbone studied the guard for a long moment, the courtroom holding its collective breath. Rather than immediate anger, a flicker of curiosity crossed the judge's features. "You appear unusually familiar with the Police and Criminal Evidence Act for someone whose primary duties involve ceremonial guard rotation. Military service requires familiarity with various legal frameworks that might impact our duties, Your Honour," Millcross responded carefully. "Indeed," Judge Rathbone nodded, his fingers forming a thoughtful steeple before him. "And yet your citation was remarkably specific." He paused, seeming to come to a decision. "Lieutenant, your correction regarding Section 24A was accurate, which makes me curious about the extent of your legal knowledge." The prosecutor shifted slightly, clearly uncertain about this diversion from standard testimony. "Your Honour, perhaps we might return to the events of September 14th. "We shall return to the testimony shortly, Miss Harrington," Judge Rathbone replied without taking his eyes off Millcross. "However, when a witness demonstrates unexpected expertise that might affect the weight we give their observations, it becomes relevant to establish the foundation of that expertise." He leaned forward slightly. "Lieutenant Millcross, as you seem particularly versed in legal matters, I find myself wondering whether your apparent knowledge is comprehensive or merely focused on areas relevant to your duties." A murmur ran through the gallery as spectators recognised the unusual turn the proceedings had taken. The defence counsel straightened in his chair, newly alert to potential advantages or pitfalls in this unexpected development. "I propose a brief assessment," Judge Rathbone continued. "A series of statements about legal principles, some accurate, some not. Your task would be to identify which is which. Would you be willing to participate in this exercise, Lieutenant?" Millcross hesitated only briefly. "If the court believes it would be helpful in establishing the reliability of my testimony, Your Honour, I am willing." "Excellent." Something almost resembling a smile flickered at the corner of Judge Rathbone's mouth. "Let us proceed, then. I will state a principle of law, and you will tell me whether it is accurate as stated or contains an error. We shall start with something straightforward." The courtroom had transformed from a formal proceeding into something far more intriguing. An impromptu test of knowledge between a decorated judge and a ceremonial guard who had dared to correct him. Even the defendant appeared to momentarily forget his own legal jeopardy as he leaned forward with interest. "First statement," Judge Rathbone began. "Under the Criminal Justice Act of 2003, hearsay evidence is never admissible in criminal proceedings, regardless of circumstances." Millcross responded without hesitation. "That statement contains an error, Your Honour. While the Criminal Justice Act did substantially reform hearsay rules, it also established several statutory exceptions under Sections 114 and 115, including business documents, unavailable witnesses, and statements made against interest." A ripple of surprise moved through the courtroom. Judge Rathbone's expression remained professionally neutral, though those familiar with him noticed the slight raise of his eyebrow, a sign of genuine interest rather than merely wounded pride. "Correct, Lieutenant. The exceptions are indeed codified in those sections." The judge adjusted his reading glasses. "Let us try something more specific. True or false? The rule in Rylands v. Fletcher establishes strict liability for damages caused by dangerous activities, regardless of intent or negligence. Partially true, but incomplete as stated, Your Honour, Millcross replied. Rylands v. Fletcher does establish strict liability, but specifically for non-natural use of land that results in the escape of something likely to cause damage. The case involved water escaping from a reservoir and flooding neighbouring coal mines. Modern application has been somewhat narrowed by subsequent cases like Cambridge Water Company for Eastern Counties Leather, which introduced a foreseeability requirement. A junior barrister in the gallery leaned toward his colleague, whispering, "That's postgraduate property law analysis, not basic knowledge." Judge Rathbone nodded thoughtfully. An admirably thorough response. Let's move to criminal procedure. True or false? Under the double jeopardy rule, once acquitted of a crime, a defendant can never be tried again for the same offence in the United Kingdom. Millcross stood with perfect military bearing as he answered, "False, Your Honour." While that was indeed the case historically, the Criminal Justice Act of 2003, Part 10, created an exception, allowing retrial for certain serious offences where compelling new evidence emerges. The first application of this exception was in the case of R.V. Dunlop in 2006, involving a murder retrial. The defence counsel was now taking notes, clearly impressed despite himself. The prosecutor had abandoned any pretense of impatience, watching the exchange with professional interest. "You are very well informed, Lieutenant," Judge Rathbone commented, a note of genuine respect entering his voice. "Perhaps something more challenging is in order. In the case of Fisher v. Bell, what legal principle regarding offers and invitations to treat was established?" For the first time, Millcross paused briefly before answering. Fisher v. Bell established that goods displayed in shop windows constitute invitations to treat rather than offers, Your Honour. The case involved a shopkeeper displaying flick knives with prices, which prosecutors argued constituted an offer for sale under the Restriction of Offensive Weapons Act 1959. The court ruled that under contract law principles, the display was merely an invitation to customers to make an offer to purchase, not an offer itself. Judge Rathbone's interest was now unmistakable. This was no longer about putting an interrupting witness in his place, but genuine curiosity about the depth of knowledge hidden beneath the ceremonial uniform. Most law students struggle with that distinction, he noted. Let us venture into international law. Is the Vienna Convention on Diplomatic Relations directly enforceable in UK courts, or must it be incorporated through enabling legislation? "It requires enabling legislation, Your Honour," Millcross replied. "The UK follows a dualist approach to international treaties, meaning they must be specifically incorporated into domestic law to be enforceable in British courts. The Diplomatic Privileges Act 1964 serves as the enabling legislation for the Vienna Convention on Diplomatic Relations in the UK." A solicitor in the public gallery whispered to her colleague, "That's the kind of question that trips up qualified barristers during admission interviews." Judge Rathbone was now fully engaged in this unexpected intellectual exchange. "You continue to impress, Lieutenant. Let's explore something more obscure. In R. v. Dudley and Stevens, what legal precedent regarding necessity as a defence to murder was established?" R. v. Dudley and Stevens established that necessity is not a defence to murder under English law, Your Honour, Millcross answered without hesitation. The case involved shipwrecked sailors who killed and ate their cabin boy after being stranded at sea. Despite their dire circumstances, the court ruled that necessity could not justify taking an innocent life. Lord Coleridge famously wrote that such a principle might be dangerous as a legal doctrine, though the defendants ultimately received a reduced sentence through royal prerogative. Judge Rathbone leaned back slightly, his gaze appraising. "Most impressive. The ethical implications of that case continue to be debated in law schools today." He adjusted his robes thoughtfully. Let us try a more technical area. In trust law, explain the rule against perpetuities and its modification under the Perpetuities and Accumulations Act 2009. Several barristers exchanged glances. This was specialized knowledge even many practicing attorneys might struggle to articulate precisely. The court reporter's fingers paused momentarily over her stenotype, seemingly as interested in the answer as everyone else. The rule against perpetuities historically invalidated interests that might vest outside the perpetuity period of lives in being plus 21 years, Your Honour, Millcross explained. Its purpose was to prevent property being tied up indefinitely. The Perpetuities and Accumulations Act 2009 reformed this area by replacing the traditional rule with a fixed period of 125 years for new trusts, while abolishing the rule entirely for commercial contracts and pension schemes. A whisper ran through the gallery. This was no longer merely impressive. It was extraordinary. Judge Rathbone himself seemed momentarily at a loss for words, his expression a mixture of surprise and growing respect. Your knowledge of trust law is remarkably current, he finally commented. Perhaps something on administrative law. Explain the Wensbury principle of unreasonableness in judicial review. Millcross nodded slightly. The Wensbury principle, established in 1948, created a standard for judicial review of administrative decisions. It holds that a court can intervene only if a decision is so unreasonable that no reasonable authority could have made it, effectively setting a high threshold for overturning administrative actions. Later cases expanded review grounds to include illegality, irrationality, and procedural impropriety, though Wensbury remains fundamental to administrative law reasoning. The prosecutor had completely abandoned her notes, watching the exchange with undisguised fascination. Even the defendant appeared to have momentarily forgotten his own legal predicament, leaning forward with interest. I find myself increasingly curious about your background, Lieutenant, Judge Rathbone remarked. But let us continue our exploration first. What is the significance of Donoghue versus Stevenson in the development of negligence law? Donoghue versus Stevenson transformed negligence law by establishing the neighbour principle, Your Honour, Millcross responded. Before this 1932 case involving a decomposed snail in a bottle of ginger beer, liability required a direct contractual relationship. Lord Atkin's judgment established that individuals owe a duty of care to those who might foreseeably be affected by their actions. His famous question, "Who then in law is my neighbour?" laid the foundation for modern negligence law, creating liability beyond contractual relationships and revolutionising tort law. Judge Rathbone was now fully engaged in what had become a fascinating legal discussion rather than a test of competence. The original purpose of putting an interrupting witness in his place had evolved into genuine intellectual exchange. One final question, Lieutenant, before we return to the matter at hand, the judge said. In constitutional law, explain the significance of Entick v. Carrington regarding executive power and the rule of law. Lieutenant Millcross stood perfectly straight, his bearing unchanged, though the atmosphere in the courtroom had transformed completely. What had begun as routine testimony had evolved into an extraordinary display of legal knowledge that few practicing attorneys could have matched. Entick v. Carrington is a foundational case in constitutional law, Your Honour, Millcross began. Decided in 1765, it established that executive actions require clear legal authority and cannot be justified merely by claims of public necessity. The case involved government agents breaking into John Entick's home to seize supposedly seditious papers. Lord Camden's judgment declared that if such actions were not specifically authorised by law, they were trespasses regardless of who committed them. The principle that executive authority must have specific legal foundation remains fundamental to British constitutional law and executive limitations. A respectful silence fell over the courtroom as Millcross finished his explanation. Judge Rathbone removed his glasses and cleaned them thoughtfully before replacing them with deliberate care. "Lieutenant Millcross," he said finally, "I find myself compelled to ask about your background. Your knowledge of legal principles across multiple specialized areas suggests formal training well beyond what might be expected in military preparation." For the first time, a hint of something almost resembling embarrassment crossed Millcross's disciplined features. "I hold a first-class law degree from Cambridge University, Your Honour. I graduated top of my class 6 years ago before choosing to enter military service." This revelation sent a ripple of surprised murmurs through the courtroom. Judge Rathbone's eyebrows rose visibly. "Cambridge," he repeated. "Under Professor Harrington, perhaps?" "Yes, Your Honour. I was fortunate enough to study constitutional law under her guidance." A small smile touched the judge's lips. "Margaret was a formidable lecturer when we were colleagues. I'm not surprised her students emerge so well versed in constitutional principles." He regarded Millcross with new understanding. "May I ask what prompted your choice of military service over legal practice? With your credentials, any chambers in London would have welcomed you." Millcross's posture remained perfect, but his expression softened slightly. "My family has a tradition of service, Your Honour. My grandfather served in the Guards during the Second World War and my father during the Falklands conflict. I felt drawn to continue that legacy while honouring their sacrifice." He paused momentarily before adding, "However, I've maintained my legal studies during off-duty hours. I find the intellectual discipline complements the physical discipline of military service." "A rather unusual combination," Judge Rathbone observed. "Both traditions serve something larger than themselves, Your Honour," Millcross responded. "Whether upholding the rule of law or protecting sovereign and country, they share common values of integrity, precision, and service." The judge nodded thoughtfully. "A perspective worth considering." He glanced down at his notes before looking back at Millcross. "I must commend your knowledge, Lieutenant. It's rare to encounter such comprehensive understanding, even among practicing barristers, let alone witnesses in military uniform." "Thank you, Your Honour," Millcross replied with characteristic modesty. "I believe I now better understand your earlier correction regarding Section 24A, Judge Rathbone acknowledged, "though I maintain that the method of delivery could have been more appropriate to the setting." "I agree completely, Your Honour," Millcross replied. "My eagerness to ensure legal accuracy led me to forget courtroom protocol. It won't happen again." Judge Rathbone regarded Lieutenant Millcross with renewed interest. The initial irritation at being interrupted now transformed into professional respect. "Your legal acumen is indeed impressive, Lieutenant, though in my courtroom, as I imagine at your post, proper procedure and deference to established protocols remain essential." "Absolutely, Your Honour," Millcross agreed. "In both settings, discipline and proper procedure serve vital purposes. My interruption, however well-intentioned, breached that protocol. I apologise again for that lapse." The judge acknowledged the apology with a slight nod. "Let us return to the matter at hand. Your testimony regarding the events at Wellington Gallery carries additional weight now that we understand your background and observational training." He turned to the prosecutors and defence counsel. Both the precision of Lieutenant Millcross's observations and his understanding of legal frameworks suggest his testimony should be given particular consideration. The prosecutor rose from her seat. "If I may continue with the examination, Your Honour." "Please proceed, Ms. Harrington," Judge Rathbone replied, gesturing for her to continue. "Lieutenant Millcross," the prosecutor resumed, "could you describe what happened after you observed the individuals loading artwork into the unmarked vehicle?" Millcross returned seamlessly to his role as witness. "I maintained observation from a secure distance while contacting Metropolitan Police via mobile phone. I provided real-time updates on the vehicle's movement through Camden, and eventually to a warehouse in Islington. Throughout this process, I was careful to remain undetected while keeping officers informed of my coordinates." And did you at any point directly engage with the suspects? No, ma'am. My military training emphasized the importance of observation and reporting without engagement when outnumbered and potentially facing armed individuals. I remained approximately 50 yards behind at all times, using urban cover to maintain surveillance while minimizing exposure. The defense counsel rose for cross-examination, his approach noticeably more respectful. Lieutenant, given your legal training, you're surely aware that eyewitness identification has reliability issues, particularly in low light conditions. How certain are you about your identification of my client? Millcross faced the question directly. I identified your client based on multiple factors, not merely facial recognition. His distinctive gait, a slight favor to the right leg, combined with his organization of the loading operation and repeated use of a specific hand gesture, created a composite identification more reliable than facial recognition alone. I observed him under 3 separate light sources during the 28 minutes I maintained surveillance. The defense counsel nodded. No further questions, Your Honor. Judge Rathbone turned to Millcross. I have one final question, Lieutenant. In your legal studies, you've examined the reliability of witness testimony. How would you assess your own testimony in light of those principles? A fair question, Your Honor, Millcross replied. I acknowledge that all testimony carries limitations. Memory is imperfect, and observation is filtered through personal perception. However, my military training focuses on objective observation and systematic recording of details. I reported only what I observed directly, distinguished between observation and inference, and documented my observations immediately to minimize memory degradation. The judge nodded, satisfied. Thank you, Lieutenant. Your testimony has been most illuminating, in more ways than one. He turned to address the court more broadly. I believe Lieutenant Millcross has demonstrated not only the value of trained observation, but also the importance of not making assumptions about individuals based solely on their current occupation. What would you do if someone underestimated you, based solely on your appearance or occupation? If this story made you think about the importance of looking beyond appearances and recognizing expertise in unexpected places, hit that like button and subscribe to our channel for more powerful stories about Royal Guards and the values they represent. Press the bell icon to never miss our uploads and check out the other videos appearing on your screen right now. Have you ever misjudged someone based on their appearance or profession? When have you seen someone handle criticism with both confidence and humility? Share your experiences in the comments below. We read every one and would love to hear your thoughts. We'll see you tomorrow at the same time with another brand new Royal Guard story you won't want to miss.